Right. Thank you all for joining us today for our 10 top tips for managing your construction contract webinar. Speaking today, we have Lauren Searson, Catherine Kay, Barry Herholdt, and Alison Garrett, and myself, and we're all members of the construction team here at Mills Reeve. We're going to cover lots of different areas today, so hopefully there'll be something for everybody, from how you choose your form of contract, to discrepancies between the ERs and contract particulars, contract dates, managing delay, notices and execution. If you have any questions, please do put them in the Q&A box as we go. We're planning to deal with questions at the end, and we should have some time to do that. So do let us know your thoughts. And as you will have seen, we are recording this session. So without further ado, I will hand on to Lauren to tell us about how you decide on the best form of contract. Thanks, Lauren.
Thanks, Alex. Due to the complexity of construction contracts and the organisational requirements of running a project, there's a fair reason why so many different types of construction contracts are in existence. Construction contracts also vary greatly in terms of complexity and size, and not one project is ever the same. There are two families of standard form contracts which exist here in the UK and generally used by the commercial development community. The new engineering contract, or otherwise what we would call the NEC, and the Joint Contracts Tribunal, known as JCT. Government has suggested the use of NEC contracts rather than JCT in the public sector, such as education, health, and local authorities. I guess one of the first questions which are required to be answered before the type of contract is selected is, how does the employer wish the construction team to operate, and where will the balance of risk versus control fall? There are two main methods of procurement: traditional and design and build. Under traditional procurement, the design process is separate from the construction. It typically involves three stages: design, bid, and build. The employer will appoint all the specialist consultants involved in the delivery of the project directly. The consultants will then complete the design documentation. Thereafter, tenders will go out, contractors will bid, and the employer appoints a contractor independent of the already appointed specialist consultants. A key difference with this method of construction is that full documentation is required before a contractor comes on board, thus making it slightly slower and possibly more expensive than other forms of procurement. If the contractor is not involved in any design decisions, this may sometimes result in buildability issues. One of the main reasons why clients may wish to go down this route is that the client retains control of design, quality, and standards. In other words, the consultants stay client side and the contractor has little or no responsibility. This may result in a higher standard project rather than other procurement routes. An example of where this may be preferable is if the client has a state-of-the-art building or a historic building, such as a grade 1 or 2 listed building. Some of the risks associated with traditional procurement are escalated budgets and multiple party responsibility for defects. If something goes wrong and it's not entirely clear where the fault lies, the client may be left having to potentially pursue the designer and the contractor, unlike the D&B, which I'll now explain, which is what we often refer to as a one-stop shop. Another word is a turnkey solution, provided it's done properly and the contractor does actually take on full responsibility for the design and build. It's probably best for projects with a well-defined scope of work. The contractor, in return for a lump sum price, not a fixed price, undertakes and is responsible for both the design and construction of the project. In other words, the client hires a contractor to perform both the design and construction under a single contract. There may, however, be additional delay costs, which my colleague Alison will be discussing a little later on in the seminar. It's important to flag here, when we speak about a lump sum price, this is definitely not a fixed price. And my colleague Catherine will be diving into more detail on her top tip number 2. Some of the main reasons why clients may find this attractive and wish to go down the D&B procurement route is that this tends to be more efficient and cost effective. If done properly, and as mentioned earlier, there is a single point of responsibility for clients. One company takes accountability for the ownership of the entire project. There's maybe a greater opportunity for value engineering, and the client obtains the benefit of the contractor's experience during the design stage. And lastly, quality and continuity of design. Research has shown that a D&B contract is now the preferred route for fit-out projects worth less than £5 million. My top tip, and top tip number one, if the parties have chosen a traditional method of procurement, the contractor can still have some design responsibility. Don't automatically assume that you have to go down the route of a design and build contract. I'll now hand over to my colleague Catherine for her top tip number 2.
Thank you, Lauren. As Lauren mentioned, I'm going to talk about contracts, and in particular fixed price contracts and or cost reimbursable contracts. In terms of the differences between the two types, essentially I'm going to be talking about the method of calculation of the price for the works. Also the pros and cons, really the preference depending on which hat you're wearing, whether you are wearing a client employer hat or a contractor hat. So essentially the works will fall into 2 particular categories, fixed price or cost reimbursement. I'll just do a quick overview of fixed price and then reimbursement. In terms of fixed price, items are paid for on the basis of the contractor's predetermined estimate. But also it will include a premium, which will cover matters such as risk and different types of risk. So these could be reflecting market conditions. Looking backwards, more recently, we'll all remember market conditions being factored in being Brexit, COVID, and more latterly, Ukraine. And we've had very recent conversations in the last month or so about how we deal with Gaza. But also the contractor's situation is relevant. It will really depend on the workload of the contractor, if they want the job or need the job, or perhaps if there's a chance of follow-on work. So there are lots of variables that will really impact on the price. Essentially, it means the estimated price to be paid by the employer, regardless of the actual cost. But however, please note, it doesn't mean that there will be no more costs, because obviously there may be some delay costs associated or variations, which we have seen on a number of occasions do trip up different parties to projects. In terms of cost reimbursement, then those items are paid for on the basis of what the contractor spends in executing the work. However, in practice, usually a combination of both methods is used throughout a contract. So the 2 types are not independent of each other, and the combination in which it's dealt with in the contracts does vary throughout the projects. But essentially, the most dominant method for determining the price is the label that we will give to the contract, being fixed price or cost reimbursable. In terms of examples, JCT standard form with quants. Most items there are included in a bill of quantities that then lead to the fixed price. The client will pay the bill rate multiplied by the quantity in the bill. Another example will be ICE, remeasurement contract, the rate in the bill being multiplied by the quantity of the item, being the fixed element on that contract. So both JCT, ICE and a number of other institutions produce fixed or remeasurable contracts, but essentially it's the basis of the payment that's the relevant point in determining matters. So I'm just going to look a little bit more in detail at reimbursement contract. Here the client takes the risk of the final price being different from the estimate. It keeps the savings but pays for increases. This is on a works paid basis of the actual cost. But in these circumstances, there aren't any guarantees that the estimated price will remain the same. Prices, as you all know, go up and go down. I'm just going to touch a little bit on naming of contracts, but particularly in the context of a payment regime. Essentially, descriptions of contracts vary enormously, but really they reflect how the payment is due to be calculated. I expect some of you will have, during your studies, been required to read a little bit from Murdoch and Hughes, if that rings any bells. Well, having reviewed what they said more latterly about contracts, they don't hold back on their views of how industry names its contracts, and how payment is dealt under the contracts, how payment is calculated under contracts. They say the construction industry uses terminology which is vague and often right down inaccurate. Well, perhaps on occasion that might be correct. For example, in a fixed price contract, it's the method of price that's calculated and fixed. It's the actual method only, really. In terms of lump sum contracts, Lauren touched on lump sum earlier. It doesn't actually mean that there's a single lump sum payment, only that specified work is to be done at a quoted price. So there can be a little bit of ambiguity about the descriptions we give to our contracts. I thought finally, I'll just touch on different types of works and pricing. Price structures vary, as we all know. Building contracts have a different price structure than civil projects. On civil projects, we usually see that they carry a greater risk than traditional projects in terms of as-built quantities are much more difficult to predict. There can be difficulties with testing due to the sheer volumes. And for that reason, quantities can often particularly be only provisional. So to conclude, in terms of pros and cons, depending on which hat you're wearing, not surprisingly, the typical preference would be if you're an employer, you would want a fixed price contract, whereas if you're a Mr. Contractor, you would want a remeasurement. But really, my top tip would be when thinking about your contract, it really does bear fruit if you spend time and effort up front deciding the best way forward before you actually delve into agreeing the actual, going into the weeds of what type of contract you're going to have. And then without further ado, I'll hand over to Barry for our next top tip.
Thank you, Catherine. Hi, everyone. Yeah, so I'm specifically going to cover discrepancies in documents as it's dealt with under the JCT 2016 design and build form. These type clauses can generally become a key battleground during negotiations and are therefore ripe for amendment. By first looking what the position is under an unamended JCT design and build form, the employer sets out certain requirements, covering any degree of detail which it considers appropriate within what we know as the employer's requirements. The contractor then responds to the employer's requirements with the contractor's proposals by setting out the manner on how the contractor proposed to design and construct the works to meet the employer's requirements. So in a nutshell, under the unamended position, if there's an error in the employer's requirements and this error hasn't been addressed in the contractor's proposals, the contractor takes no responsibility either for the content of the employer's requirements or for verifying the adequacy of any design contained in it. The risk therefore sits with the employer. And to fix the error, this will be treated as a change under the contract, meaning the contractor can become entitled to cost and time. If the error is in the contractor's proposals, the risk sits with the contractor who is responsible to fix the error at its own cost. But employers generally prefer to protect their own commercial interests as best as possible. So a common amendment under the JCT design and build form that we see is that the employer passes all the design responsibilities to the contractor, creating a single point of design responsibility. The effect of this amendment is that the contractor takes full responsibilities for any errors or discrepancies and generally with no entitlement to extra time or cost. This type of amendment is nothing unusual and contractors in the industry expects and accepts this most of the time. The position can be slightly different if there's a conflict with statutory requirements. Why? While an employer may prefer to make the contractor responsible for changes in statutory requirements, this is not usually acceptable to the contractors. The reason for that is the contractor cannot price for the risk of a change in statutory requirements that it does not foresee or could not reasonably foresee. The contractor will then deal with this by limiting the position relating to a change in statutory requirements as it is before or at the base date, meaning the contractor takes only responsibility for changes in statutory requirements if the change happens before or at the base date, after the base date, the risk transfers to the employer to some extent. For those who might not know what is the base date, it will generally be defined in the contract, but simply explained, it's the date at which the contractor is expected to have been aware of the law and similar requirements when it bid for the project. With that in mind, my top tip is this type of clause must be considered with great care, and each party should understand and be clear on its responsibilities. Where an employer creates a single point of design responsibility, contractors should be familiar with the risk that they are signing on to. For example, the expected design standard or the required skill and care duties. Thanks. Over to Alex with the next top tip.
Which is about records in a digital age. I thought I would cover this. I've been thinking about this a lot recently in the context of a case that I've been working on. And really, I think we can all agree that we've never had so much information in construction projects as we do now. It just seems to keep building up and building up and building up. And just before I move towards my top tip, I just wanted to set the scene on that. And I hope most of you are thinking about this already, but do set up a system from the beginning to store all your electronic files for each project. Ideally, have a system you're all used to, so organise them all the same way. And then obviously back them up so that you've got them if you should be in the unfortunate position of having a dispute, which can, of course, be up to 12 years or even more with the Building Safety Act now, after you originally did the work or involved in the project if you're on the employer side of it. And my client in my recent case had done all of those things. And yet still, when we have come to look at the data for court, we've had 50 or 60,000 documents in a relatively modest project. And I think if you think about it that way and imagine being in that position, great that they've got all those documents. But if you're the owner of the business who's trying to piece together what happened, or you're a witness who might have to speak, actually that's quite daunting. It's helpful if you can think about, while the project's going on, what you would do in that circumstance and actually work out for you what's best. And so really my top tip is to think about paper actually and how that can be helpful to you. And very often for people that's your site diaries, and having those available to actually refresh your memory and piece the story together and act as a contemporaneous record where emails sometimes don't always help. So I will leave you with that thought. I will move back to Barry, unless he shakes his head at me now, and we'll see if his sound's working. No, it's amazing how these things work before you. Come on, you are now muted, Barry. No, still not working. Let's carry on, shall we?
Thank you for that. I'm going to talk about the contract period, and in particular being the start and end dates. I'm going to touch on a number of themes, and some I'm just going to mention ever so briefly now. I've got a short list, which I put up there. Date of possession, time for completion, insurances, which are triggered obviously by the start date, extension of time, liquidated damages, acceleration, to accelerate or not to accelerate on a particular project, post-completion matters such as a defects liability period. So different elements triggered by the start date, some of which I'll touch on a little bit more in detail below. But essentially there are two bookends, possession and completion, which fit nicely together. In terms of possession, for example, under the JCT, there are various obligations that are triggered from the date of possession. Essentially, the contractor begins construction of the works regularly and diligently to proceed with them. I've mentioned it's a trigger for insurance. In terms of completion, typically the work has got to be full and complete performance of the work during the time specified. So getting to completion can involve lots of different elements. And it can also include elements such as delay. There are consequences in terms of times and money, extension of time as previously mentioned. In terms of time for completion, what does it really mean? Well, the contractor is bound to undertake the work within the period set and liable to damages if it does fail to complete by the allocated time. It is entitled to carry out the works, but there are particular events of prevention that might come to cause problems in relation to this, such as possession being restricted or partial possession for various reasons. In such circumstances, the contractor is entitled to damages. But if no actual time period is set for an end date, the same principles do apply. The contractor must complete within a reasonable time. I just touch on extensions of time. Generally, the contract will provide for extensions of time on various grounds. Some will be neutral and others less so, with consequences for matters such as liquidated damages. In one of the contracts, one of the particular clauses in particular reads, the contract is entitled to an extension of time on the ground of other special circumstances of any kind whatsoever. So just hold that thought whilst I'll bring another comment up later. I'll just touch on post-completion, end date obviously, which is a trigger for various events. We've talked about insurance matters coming to an end now, usually, but the obligation of the contractor to remedy any defects that may appear within the relevant period, specified period, being usually 6 or 12 months after practical completion. Or if it's a contract such as a maintenance contract, then the contractor might be obliged to maintain the works. Or there may be a situation where it's been agreed that the contractor will put right defects that may not be caused by the contractor, but there may be employer maintenance issues. And of course, in those situations, typically the employer client would pay the cost of those. But note, these situations don't usually, under most contracts, absolve the contractor of all responsibility for repair of defects beyond the period of the expiry of the defects liability period. There's still that ongoing responsibility. I mentioned an earlier little quote in terms of a similar theme in MF1. There's a particular clause in there that specifically says that the contractor is expressly absolved of further responsibility after carrying out rectification of defects. So contracts can differ in their approaches to this. So having mentioned those two comments, I'd say that my top tip would be check really carefully that the clauses actually say what you think they say. And if they don't, then obviously one would try and make them either clearer or amend them to follow the approach that you're expecting or that the parties expected them to reflect when they took on the project. And now I will hand over to Alison. Thank you.
And Alison, just before you go ahead, Barry, do you want to see if your sound's now working? No. Okay, thanks, Alison. Please go ahead.
Thank you, Alex. Yes, I'm going to be dealing with the next two top tips, and they both relate to delay, a common factor on a remarkably large number of construction projects. Top tip 6 relates to extra time. And before I go on to actually deal with the top tip, I want to give you some of the background. First, and Catherine has touched on this a little bit already, but where you have a delay, which is an employer's risk, so wider than an employer's responsibility, an employer's risk, then the contractor can get more time to complete the work that it was due to undertake, and as a result will not have to pay delay or liquidated damages to the employer. And I'll come on to talk about that in a bit more detail in a moment. And in some circumstances, the contractor can also get extra money for the delay to it in completing the work, because it'll be on site for longer. So it'll incur things like site setup, it'll have labour on site for longer, those sorts of things. It can sometimes claim for the extra cost of that. Where the delay is the contractor's risk, then the contractor is liable to the employer for damages for the delay caused to the employer. And they're dealt with by one of two ways. Most commonly, they're dealt with by what are known as liquidated damages, if you're using a JCT contract, sometimes known as LDs. Previously used to be called liquidated and ascertained damages, or LADs. Or if you're using NEC, they're called delay damages. And they're a pre-agreed amount of damages that the parties have agreed between them, that if the employer suffers a delay in completion of the works, it will suffer damage on a per day, per week basis of that amount. They can be difficult to calculate, but the parties usually try to agree them between themselves. In the past, the gold standard was that they needed to be a genuine pre-estimate of the employer's loss. That is now one of a number of factors that are considered, but it's not the only factor. The alternative to liquidated or delay damages is that when the works are actually complete and the employer can work out what its actual loss has been, it can claim that amount from the contractor, and they tend to be known as general damage claims. And here I come to my first top tip, which is really for the benefit of an employer. Employers, be careful if you have decided not to claim liquidated or delay damages, but you do want to claim general damages. If you put in the contract particulars or the contract data next to liquidated damages, nil or 0 or 0 or anything like that, there is a relatively strong argument that you, without further wording, you're choosing both to exclude the right to claim liquidated or delay damages and the right to claim general damages. There was a 1980s case about this, which found to that effect. And at the moment, it is still good law in England and Wales. So avoid, as an employer, if you want to claim general damages, avoid putting nil, 0, anything similar to that in the contract particulars or the contract data. Turning to my next top tip, this is more contractor focused. And here I'm looking at condition precedents that are sometimes set for contractors to be able to claim for more time and money as a result of delay. So by way of background, I'm just going to try and explain how the JCT and DB 2016, and indeed a number of other JCT forms of contract, deal with time and money as a result of delay, and compare it with NEC4, partly as a reminder to you all. JCT Design and Build and other JCTs split claims for delay and time and money. So you claim time separately from money. If you, as a contractor, want to claim extra time, then you have to show that there has been a relevant event which has delayed the date for completion of the works. The relevant events are set out at section 2 of the Design and Build form of contract, and I think there are 14 of them in total. And if you, as a contractor, are successful in getting an extension of time, then you get relief from liquidated or delay damages. You do not have to pay those damages to the employer. If you want to claim the loss and expense, the cost to you of being on site for longer, you have to claim a relevant matter. And that's set out at section 4 of JCT Design and Build. And there are, subject to subsections, 5 relevant matters. And they include things, as you would expect, a change by the employer to the work, or an impediment, prevention, or default, or default by the employer. Those relevant matters are all relevant events as well. But you don't have to be any mathematician to work out that if there are 14 relevant events and 5 relevant matters, there are 9 items that fall in between. They are neutral events, and they include things which I think most of us would say were neither the responsibility of one party or the other. And they include things such as exceptionally adverse weather conditions, and force majeure. So in those circumstances, the contractor gets relief from having to pay liquidated damages because it gets an extension of time, but it will not get any money for being on site for longer. It's a balancing act. NEC4, and indeed other NEC3 as well, ECC, provide for an all or nothing situation in terms of time and money. You either get both or you get neither. And they're dealt with at clause 60, compensation events. Next slide, please. So turning to the point, the link to my top tip, I want to talk about condition precedents, both in relation to those forms of contract, by which I mean a clause that only comes into effect when a specified condition is met, or in other words, what steps a contractor has to take in order to be able to claim more time and money. So under JCT Design and Build, there are two clauses which could arguably have amounted to a condition precedent. Under 2.24, where a contractor wishes to claim extra time, it has to, when it becomes reasonably apparent that the progress of the works is likely to be delayed, forthwith give notice to the employer. And under clause 420.1, in relation to money, i.e. loss and expense, the contractor shall notify the employer as soon as the likely effect of a relevant matter on regular progress becomes reasonably apparent to him. Now, in both those instances, it has been held that they are not condition precedents. If the contractor doesn't comply with those timeframes, which quite frankly are quite vague anyway, what does a reasonably apparent mean? It doesn't prevent them from being able to claim extra time and extra money. Compare that with NEC4, where we have at clause 61.3 the following clause. If the contractor does not notify a compensation event within 8 weeks of becoming aware that the event has happened, the prices, the completion date, or a key date are not changed. And then there's a large carve out here, unless the event arises from the project manager or the supervisor giving an instruction or notification, issuing a certificate, or changing an earlier decision. So unless the carve out applies, this is a condition precedent. The contractor must notify a compensation event within 8 weeks of becoming aware of that event, whatever that may mean. And there may well be discussion about when the contractor became aware of something. But in principle, that is a condition precedent. And in relation to that, as by way of background, you'll find that bespoke contracts and particularly subcontracts often contain condition precedents for a claim for more time and money. So my top tip relates to what you should look out for as to whether something is a condition precedent or not. Firstly, there's no need to have the words condition precedent for something to be a condition precedent. If the wording if is included, as it is at the beginning of the NEC4 clause that I've just mentioned, or if the wording provided always that is there, then that's an indication that you might be looking at a condition precedent. If there's a deadline, and if there's an indication about how the party fulfills the deadline and what the consequences are if the deadline is not met, they are also indications that you might be looking at a condition precedent. A party might have to take certain action, failing which it loses its right to claim for any delay, time and money caused by delay, which is not its responsibility or risk.
How to claim liquidated damages under the JCT contracts. So apologies for the amount of text on this slide. I hope given you're all on your own screens, you'll be able to see it. I wanted to talk you all through the wording of this clause because I suppose this is a bit of a spoiler, but my top tip here is really to read it properly, because actually the drafting isn't that clear to most people. So first thing to note is that there are 4 notices required potentially to deduct liquidated damages under the JCT forms of contract. This clause is from the design and build, but there are similar ones in various of the other contracts. So those 4 notices are the non-completion notice, a notice stating that the employer may require payment of or may withhold or deduct liquidated damages, the notice, which seems to be the main purpose of the clause, which slightly confusingly, which is the notice that liquidated damages will be withheld or be required to be paid. And then if you deduct liquidated damages from sums due, then the employer has to also issue a payless notice, and you'll see that's buried in the footnotes. And when you look at each of these 4 notices, very often you have to refer to somewhere else in the contract beyond this bit of the clause to be able to understand what is required. So for the non-completion notice, that's clause 228. Key things to note are that if the completion date should get changed after the non-completion notice has been issued, then the notice is effectively void, and you have to reissue a further notice if the new completion date is not met. So even if the new completion date's already passed, it doesn't matter, you should issue a new non-completion notice. On the second one, it does fairly much do what it says on the tin. So the employer must notify the contractor that the employer may require payment of or may withhold or deduct liquidated damages. And note the various options in that. Employers, make sure you include them all in your notice, and contractors, if you notice that they aren't all included, just keep an eye out when the money is eventually deducted as to whether they use the method of claiming the money that they've stated in the notice. Slightly confusingly to my mind, although perhaps it's helpful, at 229.4, the clause confirms that this requirement remains satisfied once you've issued a notice saying that you may require payment of LADs, even if the non-completion notice falls away and you have to issue a new one. So moving on to the third notice, that the requirements for that one are set out in 229.2. So again, like the previous notice, keep an eye on what it says. So the employer requires the contractor to pay liquidated damages at the rate stated in the contract particulars, or if you've got a reason to do so, a lesser rate stated in the notice, so that a lower rate is okay, and in which event the employer may recover the same as a debt. So it can either say that, or it can say that liquidated damages will be withheld or deducted. Note, employers, again, that there's an and there. So you can put both of these in your notice and then choose to which one you use later, which is obviously gives you more flexibility and is to be recommended, and contractors keep an eye out if that isn't done. And then the final notice is where, as I say, deduction of liquidated damages is required. And then you flip to the footnote. And that then you'll see refers you to clause 495 for how to give an appropriate payless notice. And that clause says that you have to serve that notice 5 days before the final date for payment of the payment that you are withholding against. And then it refers you to another clause, clause 410, and that sets out what that notice has to say. So it has to specify the sum the employer considers to be due to the contractor at the date the notice is given, and the basis on which that sum has been calculated, i.e. it's the amount and how the first figure was come to, and the deduction based on liquidated damages and the reasoning applying to it. So lots to unpack in a relatively short clause. So as I say, do read it and keep reading, because actually I think it's quite easy to miss several of these notices, and particularly that there's 2 different ones between the second and the third. And with that on notice, I'll pass back to Barry to tell us more about general notices under the contract.
Thank you, Alex. In contrast with the discrepancy clause I covered earlier, the notices clause is one that can easily be overlooked by parties during negotiations. But they are quite important, as we've just heard from my colleague about condition precedents and the various other clauses of a contract. They may require some form of notification. So when drafting a notice clause, it's important to consider if the following key points should be covered. The service method, how the notice should be served. Generally, the contract will provide that the notice may be given or served by any effective means and shall be duly issued if delivered by hand or sent by prepaid post. Look out for bespoke amendments that go further than this and allow service by email. In contrast, we've also seen some bespoke contracts that can expressly prohibit notice to be given via email. The next one to consider is where. Agree and address where the party is required to issue a notice. The aim is to avoid any risk of issuing your notice to the incorrect address. There will be times where parties forget to specify an address in a notice clause. When faced with this scenario, consider if the contract identifies other methods of service, and if so, use that method, or check where statute may apply if statute allows for service by a particular method. If neither the contract or the statute can assist, use any method that will bring the notice to the other party's attention. The next point to consider is, should the notice be in writing? Because of the various challenges that can potentially arise if you wish to prove an oral notice, it should normally be mandatory for the notice to be in writing. A point worth mentioning is, for most purposes, English law already regards emails as writing, unless otherwise agreed under the contract. Another point is the language. This is an obvious one. Choose the language that parties will be able to read and understand. And then we get to a next point, the timing of the notice, by when it must be served or when does it get treated to be deemed service. Timing is quite important because if you want to avoid any time bar issues, you can understand why. Check if any prescribed periods are stated in which certain notices need to be served under the contract. Be alert to contracts that goes further and expressly sets out specific business hours. To avoid any uncertainties, it's always good to include clear details or a table that sets out deemed service periods. As an example, you can state in a contract on the day of delivery if delivered by hand or by email, or on the second business day after the day of posting if it was sent by prepaid post. The last point to consider is, should the notice be signed? Look if it's a requirement for the notice to be signed by or on behalf of the party that's giving the notice. An electronic signature will generally be valid if it's intended to authenticate the document, i.e., typing a signatory's name or initials into an email can be sufficient to be a signature. With that all in mind, my top tip on this is don't ignore or overlook the notices clause during negotiations. Parties should agree all the notice requirements from the start and set out clear practical requirements that will help to avoid any risk or confusion. Thank you. I now give you over to my colleague Lauren with the next top tip.
In the context of a contract, execution simply means the way in which a legal person enters into a document or a deed, giving it legal effect. There are two ways of executing a construction contract, either as a simple contract, which is what is known as underhand, or as a deed. If the applicable formalities are not properly observed, this could affect the validity and enforceability of the contract concerned. Deeds have more onerous formalities than simple contracts in order for them to have legal effect. So this is what I'll be focusing on for the rest of the talk. In order for a deed to be effective, it has to be in writing, be clear on the face of the document that it's intended to be a deed. The face value requirements is what we call it. You probably would have seen this on a deed. The wording at the start of the deed usually says, this deed is made on the. And at the end, there is wording that says, executed as a deed by. And then you have the execution blocks. We'll look at these blocks shortly. And the third requirement is that it must be validly executed as a deed by either the company or the person signing it. Depending on who is executing the deed, there are also various legislative requirements which one has to comply with. And these can be pretty complex. My top tip number 10, ensure that when you're signing a deed in the presence of the witness, that the witness is actually physically present and in the same room as the person executing the deed. And I'll go on to explain why. The majority of the corporate world are working from home most of the time, and remote working is now considered a norm. The question crossing most people's mind is, does this then mean that the witness is required to be in the same room, i.e. what I've just said, my top tip, physically present, as the person signing the deed? Although the Law of Property Act 1989 and the Companies Act 2006 require the presence of a witness, they don't actually specify what physical presence is, and it's not clear whether remote forms of witnessing is included. We, however, helpfully and thankfully have guidance from the report on the electronic execution of documents published by the Law Commission in September 2019. It provides that, with specific regard to deeds and the witnessing requirements thereof, a deed must be signed in the physical presence of a witness who attests the signature. This is the case even when both the person executing the deed and the witness are executing or attesting the document using an electronic signature. Therefore, in order to be certain that a deed has been validly executed, the witness must be physically present to witness the act of the signature, whether that signature is applied electronically or otherwise by the person signing the deed. Remote witnessing via a video link or screen sharing is not considered permitted. This is in order to minimize any evidential risk as to whether the person generally witnessed the signature. I'll now hand back to Alex, where we will have a quick Q&A session before we end today's set.
Thanks very much, Lauren. So if I can start with a question about liquidated damages and what you should do if they are just way too high. Alison, I don't know if you're able to cover that one.
Yes. Well, in terms of liquidated damages, if you've got two commercial parties, it's highly likely that if you've agreed a figure, the court will uphold it. But in some circumstances, they might not, and particularly if one party is not a commercial party, then it might be the case that the liquidated damages could be held to be a penalty. And if they are a penalty, that will mean there can be no claim for liquidated or delayed damages as such. But somewhat ironically, in my view, bearing in mind what I said earlier about the fact that if you put nil or naught in your contract particulars or contract data, you lose the right to claim either liquidated or general damages. If your liquidated damages clause is held to be a penalty, as an employer, it doesn't seem to me that it will stop you being able to claim general damages.
Thanks, Alison. We've had a few questions about liquidated damages and how you claim them under the JCT clauses. So there's been a question about whether a third notice out of the four I was talking about remains satisfied and could therefore be used for two separate pay less notices. The answer to that is yes. So if you've got an amount that's been notified under your first three notices, but you don't have enough money in your first interim payment for the whole of that amount to be withheld, then yes, you can then move that onto the second one without reissuing all of the other notices. And then another question, where LADs are due, do these ever get settled and agreed outside the contract on a commercial basis? Or always as per the contract? I think that they do sometimes get settled commercially. Absolutely. My experience of that has been that that's generally the case where they're part of a wider dispute. So if you've got lots of things, they quite often get all wrapped up together if there's been lots of problems with the contract. Another question, can you mix electronic signatures with physical wet ink signatures? Lauren, do you want to take that one?
Thanks, Alex. Yes, there is actually a practice note that the Law Society published a couple of years ago. As long as each party is using a legally effective method of executing their deed, it is permitted. So, for example, a company signs wet ink and the other company executes via an electronic means such as DocuSign, or they use their corporate seal. As long as it's a legally effective method, the combination of the two signings are permitted. What I would advise, though, is probably 2 points in terms of having an audit trail where the parties have agreed to create a composite document at the end of the two separate counterparts. And I would also probably include a counterparts clause, so in the body of the document, to ensure that's included in the contract, and it clarifies that separate copies of the agreement may be executed by different parties, and in this example, by different means, and each copy will be considered an original. Those would be my tips.
Thank you. We've had a follow-on question on that. It's about sealing a document electronically and whether that's valid. I don't know if you've come across that, Lauren, or if someone else would like to pick it up.
In practice, I actually have never come across a electronic sealing. Most of the clients have quite strict constitutional provisions, and they undertake a sealing meeting, and it's done in hard copy. So I'm going to have to revert if any of my colleagues have dealt with electronic signatures, otherwise sealing, otherwise I can revert and look into that in more detail.
I think I can add a little bit there. I think there are some companies now who've been able to obtain an electronic seal. There are still a lot of organisations that can't haven't been unable to acquire an electronic seal. But if a company has an electronic seal and their articles allow them to seal in that way, then there's absolutely no reason why they can't do that by DocuSign, is my understanding. I don't know whether anyone else has any thoughts on that at all.
Yeah, no, that was my understanding as well. Although, like Lauren, I can't say I've actually done it.
My understanding was, and I am trying to remember where I read this, that certain local authorities in particular are trying to acquire electronic seals so that they can use them and use DocuSign on a more regular basis. And so far as I can tell, although things have slowed down a bit following the end of lockdown restrictions, there's a move generally to try and persuade organisations to be able to seal with an electronic seal.
We've had a follow-up question again to all of that on execution, and we anticipated this might be quite popular because we do get a lot of queries. So, can two signatories be used to execute a deed to avoid the need for a witness? Absolutely. With most company arrangements, two directors or a director and a company secretary will be valid. So yes, if the witness seems more difficult than getting hold of two directors, absolutely you can do that. Sometimes, or very often, actually, it's getting hold of the directors that's more difficult than the witnesses. So that's why often clients will choose to go for the witness option. Catherine, I know you've got quite a lot of views on execution after lots of experiences. Is there anything you'd like to add?
I suppose what I would say is over the passage of time, over the last couple of years, it's all got a lot clearer. Some clients do it on a fairly regular basis now. A lot of clients would never turn the clock back and go back to how we did it in paper and only use electronic signature. There is a little bit of confusion amongst some signatories when not necessarily when it's a hybrid situation, but where there's a signatory and a witness. And as far as I understand, organisations like DocuSign or Adobe don't set a time limit on what the witness or the time frame within which witness should actually deal with what it needs to do. By that I mean someone might witness the signature but then sign a little bit later. So different law firms or different organisations do set a time limit on the period when that signature should be applied. We have a 2-hour window. It's not a DocuSign rule, it's a Mills Reeve rule. And if we want to change that, then we've got to go to someone very, very senior to change the Mills Reeve rule. It's very hard. I think a little bit of the confusion is that DocuSign don't have that rule. I'm not sure about Adobe. And as you can imagine, different law firms have a slightly different time frame. So those that sign quite a lot can sometimes be a little bit confused as to why there's slightly different rules as to when a witness needs to seal. And I've seen in the comments that a number of attendees have mentioned that they do use a seal and they use it electronically. So I'm quite interested in that because we do a lot of documents by seal. Typically when I do a hybrid, so the document will always be signed electronically by one party, then we will print off and the hard copy delivered to the organisation applying its seal. So it's quite interesting seeing the comments coming through. So other organisations are following different methods. So I think that's something that we will start to explore now. So thank you for that.
Again for joining us, and yeah, have a good rest of the day.